Welcome to County Portal, your simple source for local government services and public records. Let's get started.
So you've received a decision from a district court and you're not happy with the outcome. Today, we're talking about how to appeal that decision. It's a complex process, so let's break it down. First and most importantly, an appeal is not a new trial. You don't get a do-over. You can't introduce new evidence or bring in new witnesses. The purpose of an appeal is to have a higher court, called the Court of Appeals, review the district court's proceedings for legal errors. The appellate court is asking one main question: did the trial judge make a mistake in applying the law that affected the outcome of your case? This could be anything from misinterpreting a statute, to improperly admitting or excluding evidence, to giving the jury incorrect instructions. It's not about whether the appellate judges agree with the final decision, it's about whether the process was legally sound. The very first step is filing a notice of appeal. This is a critical and time-sensitive document. In federal civil cases, you typically have only 30 days from the date the final judgment is entered to file this notice. For federal criminal cases, it's even shorter, usually 14 days. If you miss this deadline, you almost certainly lose your right to appeal forever. Once the notice is filed, the next phase involves compiling the record on appeal. This is all the paperwork from the trial court, including motions, orders, and most importantly, the trial transcript. The appellate court needs this record to see exactly what happened below. After the record is prepared, the real legal work begins with writing the briefs. The person appealing, called the appellant, files an opening brief. This is a detailed written argument that identifies the legal errors made by the trial court and explains why they matter, citing relevant laws in past cases. The other party, the appellee, then gets to file a response brief, arguing why the district court's decision was correct. The appellant may then get to file a final reply brief. In some cases, the court will schedule an oral argument. This is where lawyers for both sides appear before a panel of 3 appellate judges to argue their case and answer the judges' questions. Finally, after reviewing the briefs and hearing arguments, the panel of judges will issue a written decision. They can affirm the district court's decision, meaning it stands. They can reverse it, meaning you win the appeal. Or they can vacate the decision and remand the case, which means they send it back to the district court for further proceedings with new instructions. Appealing is a long, expensive, and difficult process with a low success rate, and it absolutely requires the help of an attorney who specializes in appellate law. Thank you so much for watching. If you found this information helpful, please hit the